Folks, should we get started? Does that work for everybody? Okay. All right. Well, thank you all for coming. My name's Joe Pereira. I'm with the Colorado Office of the Utility Consumer Advocate. I'm going to push. We have lots of food for folks, so if you're hungry, if you need a snack, whatever, please dig in. We also have translation services available for folks if there's here now or come during the presentation. We can facilitate that as well. Thank you for the invitation to come and chat with you all today. I'll point out Adrian has really been the catalyst and connection to get me up here and talk about kind of a precursor for the Public Utilities Commission hearing that's coming next Wednesday at this location. So as I mentioned, my name is Joe Pereira. I'm the Deputy Director of the Colorado Office of the Utility Consumer Advocate. It's highly likely you've never heard of us before, right? We operate in this small little niche at the Public Utilities Commission and at the courts and sometimes at the Federal Energy Regulatory Commission. We do mostly energy work. We do some telecom specifically related to 911 and occasionally some other public advocacy work, but generally we do work in front of the Public Utilities Commission around electric and gas service. So our office is small. We sit within DORA. There's between like 9 and 14 full-time employees, and then we have 5 lawyers that represent our office from the Attorney General's office. So pretty small. Small little budget, somewhere in the neighborhood of like $3 to $4 million annually, and we handle something like 70 cases or so before the PUC, kind of at any given time. Our charge is to represent the public interest before the PUC. So what's the public interest? That's a amorphous question that we could answer differently kind of on any given day. What's important to understand about our office that's different than the PUC is that we are generally an advocate, not a regulator. So we don't make decisions on anything. What we do is we go before the PUC and provide a perspective on, this is what we think is in the public interest based on our statutory charge, based on our experience there, based on lots of case law and that kind of thing. We generally are thought of as representing the class, like the residential class of customers, so not one customer in particular. Same thing, the small business class and then the agricultural class when we do our advocacy. But we point to that public interest piece first. And so in the public interest, we also have kind of an outreach effort, which is what we're doing here tonight. When big cases or important cases come before the Public Utilities Commission, we try to do outreach in front of these public comment hearings to inform the public on what's going on, use our experience and say like, hey, this is what to expect at your public comment hearing, give you some information about what is the PUC, what's going on, and then ultimately, based on our experience, here is maybe a more effective way to give public comment hearing to the commissioners so that they can use that in their decision-making process. And so that's what I'm going to try to do today. How does our office make its decisions in advocacy, or what guides us? So statute tells us we have to consider all of these things when we're developing advocacy: rates and charges, decarbonization goals, just transition, environmental justice, and short and long-term impacts. So you could see, like at any given time, like we're trying to weigh all of these all of these pieces in our advocacy, and then give you all, when I do this work, kind of information that reflects kind of perspectives on those charges. So that's who I am. That's what we do. I should say I have a presentation, but if you have questions like as we go, please feel free to jump in. And we're going to talk about the PUC. It's like not the most exciting content, right? And so like the more conversational we can make this, probably, the easier it goes for all of us. So.
All right, Joe, then I have a question for you.
Sure.
So with the things that you consider, this is a fabulous list. When we talk about like rates and charges, I understand that, what I pay as a customer. Within here, are you all considering the social cost of carbon for projects that come up?
So I'm gonna answer that, but first I'm gonna say we're also recording this tonight, and so if there's a question, we probably can't hear it on the recording. So I'm gonna do my best to repeat the question so we have it on the recording and then answer that. So the question was, when an office like ours considers our advocacy around all of this list, do we include things like social cost of carbon? So the short answer is yes, but why? And the reason is that the legislature gives us direction on what we would consider. And so the state considers things like decarbonization and the social cost of carbon within its laws in making these decisions. And so that's why an office like ours would include something like that in its advocacy. Okay, so why am I here? I think I covered this a little bit. Try to be an educational resource for what's going on with Public Service or Xcel Energy's Mountain Energy Project. I'll discuss the PUC and the process a little bit. I'll talk about the hearing process, or how does this all shake out, and then give my best perspective on how to give meaningful public comment when Commissioner Gilman comes next week. I think I said this already, but make it clear, the UCA is a party in this case, and so the UCA will have an advocacy perspective. I'm not a witness in the case. I'm not writing testimony or doing anything like that, and so, but I do know a lot of the facts of the case. I can try to answer questions and details and those kind of things as much as possible, and I'll do my best to not reflect or push or promote the advocacy position of the UCA in our discussion. Okay, so what's the PUC? Who has no idea what the PUC is? Okay, generally educated room. Who feels like they're an expert on the PUC? All right, not me. So the PUC is a regulatory body established to oversee utility service in a wide variety of areas. So electric and gas is what we're talking about with the Mountain Energy Project, but they oversee telecom, transportation, like limo and charter service. Like they used to cover railroads. I don't think railroads are still involved with the PUC, like determining crossings and all of those kind of things. They're mandated to give paramount consideration to the public interest. Well, there's that term again. Basically, they're going to try to weigh in decision making, they're going to try to weigh the different interests, laws, rules, and then perspectives of local communities in making a decision in a proceeding around a utility. They're quasi-legislative and quasi-judicial. So they get their guidance on what they do from the legislature. Top line law, but as laws are pretty amorphous, and then there's all that rulemaking and all the thing that happened below it, and that's where the PUC is doing its legislative role. And they're also quasi-judicial, so they act as judges in proceedings, and that's what they're doing with the Mountain Energy Project. And they will act that way at the public comment hearing next week. So The PUC is administered by 3 governor-appointed commissioners. The commissioners are Senate confirmed, and they also have a large staff that works underneath their purview. So in this case, the legislature sets out that 2 of the commissioners are of the party of the governor, and 1 is not of that party. So that's normally has been thought of as, Democrats and Republicans, or Republicans and Democrats, but here in Colorado, we also have a large not party, right? And so the configuration in Colorado right now is 2 Democrats and an unaffiliated commissioner. The chairman of the commission is Eric Blank. He's from the Boulder area. History of renewable energy development, lawyer by trade. The unaffiliated commissioner is Tom Plant from the Buena Vista area, longtime legislator, former director of the Colorado Energy Office, a long history in energy. And the 3rd commissioner is Megan Gilman from down the road, Eagle County. She has also worked in energy work for a long time, and she is the hearing commissioner for this proceeding. And I'll get into that a little bit more in a minute. So how does the PUC process work? So the applicant, which is the utility, files a direct case that says they want to do something. They either do that voluntarily or because they're mandated to do it by statute or by the commission, months, years ago, whatever. So that case gets filed. In this case, Public Service filed the Mountain Energy Project. It's a big, long application, and it has lots of witnesses and that kind of thing. And they say, we want to do this to address this problem in this area. Then the PUC notices the filing and opens what's called an intervention period. This is to determine the formal parties within the case. So in the Mountain Energy Project, it's parties like our office, the PUC staff, environmental groups, local communities, anyone that can demonstrate or show a pecuniary interest in the proceeding. There's 2 ways to get in. One is by right. So the legislature says, UCA, all you have to do is say you want to be in a case and you're in. Then there's what's called permissive intervention. That would be more like a local community or an environmental or interest group. And they would have to apply and say, this is the reasons we think we should be let in. And then the PUC will review those and say, okay, these are the parties to the case. And these parties are the ones that get to present formal evidence, present witnesses, and cross-examine witnesses in kind of this quasi-judicial forum. And so think about the way the PUC is going to operate is kind of like court that you see on TV, but not like that at all, right? Not exciting. There's no Matlock moments. None of that is happening. It's kind of these long proceedings where, minutia and that kind of thing that worked out. So I mentioned parties get established. There's a schedule, and then all these other procedures are established within the case. And so that's all been done. A hearing type is determined. There are a couple ways that the commission can hear a case. It can get sent to an administrative law judge. The whole commission can hear it, all 3 commissioners. That's called en banc. Or in this case, which is actually kind of rare, we don't see it very often, they'll appoint a hearing commissioner to act as a judge. And so Commissioner Gilman is the hearing commissioner. In this case, I mentioned she has a strong background in energy, but I think nationally she's really well known to understand natural gas issues, natural gas decarbonization issues in particular. And so she's pretty steeped in the content of this case. Any questions on any of that yet? Okay, we're still talking process. So, so we have this, court case developing, and the way the PUC works is rather than have direct testimony, i.e. like a lawyer asking their client on the stand a bunch of questions in front of the judge, we have written testimony. So witnesses have written down the questions that they want to be asked and the answers that they want to those questions, and they present it to the commission, and that's called answer testimony. That's been filed already just 2 weeks ago. This is where the parties lay out their response to what the company has put forward and their alternatives and critiques of that case. It uses experts to lay out these arguments. Sometimes they're technical experts, sometimes policy experts, but it essentially frames like these are the people that are going to speak for our case in front of the commission. There is no limit or range to what these witnesses can say. They don't have to respond to the company's case directly, or they can directly say, you know what Xcel filed here is terrible. We want, something completely different, or hey, we agree with this completely. And the idea here is that the commission is starting to use these documents to build a record for its decision making. And ultimately that frames what the commission can and can't do in the case, the record. You'll hear it, in the public hearing, Commissioner Gilman or somebody will say like, we're here to develop a record, blah, 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 blah. So you hear this term, the record, all the time. And this is basically the evidence in the case. The next step is what's called cross-answer or rebuttal testimony. And so this is coming up in just a couple weeks. This is the ability for parties within the case to, now that they've seen the other party's comments, to write and say, we don't like what this party said. And with cross-answer testimony, you're not allowed to do what's called friendly cross. So you can't write anything that says, we really agree with this party, or this is really smart. You just have to kind of poke and prod at the other party, which isn't great, and people kind of pick and choose their punches on this, but that's how it's set up. And then the company also gets to respond again to what the parties have laid out with their argument, and that's called rebuttal.
Joe, is the alternative approaches for consideration, is that like the NEPA process where there is a alternative 1 through 3 where one is no action, one is the utility proposal, and the third, where do those alternatives come from?
So the alternatives would come from the party. I'm sorry, that's a great question. The question was, where is this, when I referenced alternative approaches for consideration, is that like the NEPA process, i.e. You agree with the company, you propose a different alternative, and I'm sorry, what was the third?
The last one is usually a no action.
The third being a no action. It's not as restrictive as the NEPA process. Basically any party can put forward alternative ideas or approaches. And then if it's based on evidence and that they've built the case and carry the burden of that new argument, then that allows the commission to consider that alternative. So it could be we agree with the company, but it could be we propose a completely different approach that hasn't been contemplated at this point, and we are using our expert witness to introduce evidence and carry the burden to put this new alternative on the table. And in this case, there are a lot of just there are a lot of parties and there's a lot of answer testimony already. And so most likely this is happening on lots of issues. Other questions on just kind of fun process stuff here? Yes, sir.
Does it often happen that the commission will suggest something totally different?
So the question is, does it often happen where the commission considers or adopts alternatives? I would say more often than not, alternative approaches are considered, and that the commission comes up with the outcome that it likes most. In my 10 plus years working in front of the commission, I can't, unless all the parties agree, I can't remember a time where the commission would just adopt any company's proposal just as presented. I mean, they're almost always changed. The commission almost always has a perspective, unless, it goes completely uncontested or it's a settlement or something like that. So I would anticipate in this proceeding, you will see the commission consider a broad range of perspectives, and the final outcome will look different than what the company has presented. What direction I would not begin to speculate on, though. So there's also now public comment, right? This is what we're here to kind of understand. The commission will hold kind of multiple public comment venues. They'll allow for written public comment and all of this. The commission has been very deliberate in the last couple years on trying to incorporate public comment more readily in its decision making. I think this is a good thing. This is one of the things we're trying to support the commission in doing, and also, like, we have seen at UCA has seen public comment, I think, really matter in the direction of decision making from the commission. So I don't think it's just an academic exercise for this commission as it's composed. I think it is meaningful, and they do use it in considering where they're going to land. So there will be a hearing coming up. This will involve the cross-examination of witnesses. So the direct examination was written, cross-examination is live. So if you're a witness for a party and you said, reject the company's plan outright, the company gets a chance to put you on the stand, and their lawyer gets to ask you questions about the evidence you put forward and why they think you're wrong, and then your lawyer gets a chance to do redirect and kind of correct all the areas that they maybe don't like, or line of questioning that they felt was incomplete or something like that. So once that's done, the commissioners will meet in public. They're not allowed to communicate with each other at all on any of the decision points or any of the evidence. So they'll hold a public meeting where they deliberate on a laundry list of different issues that get brought up on the proceeding, and they'll use that for decision making. They'll talk back and forth. They'll consider evidence. They'll propose to each other alternatives. They'll say, yeah, we thought this witness's testimony was really compelling. Like, it'll be a long conversation about the case. Usually, they'll kind of do some votes, or you'll get a pretty good sense of where they're going to be on any particular issues. If they have issues they can't resolve, they'll kind of table it, and they'll schedule a meeting for later where they can think about, hey, this commissioner put this idea out there. I hadn't considered it. Let's come back in a week and I can do my own research and think about the evidence, and we'll talk about it some more. And so sometimes deliberations, were 1 or 2 or 3 different meetings. Once that's done, ultimately they'll put out a written decision, and that is kind of the official decision of the commission on what they want to do in this proceeding. And then, of course, like everything in administrative law, that's not the final word, right? So parties get to say, no, I don't like that decision. You didn't consider my evidence. And so we'll write, another brief and say, no, we want you to rehear, re-argue, or reconsider something in the case. And we'll do kind of multiple rounds of that. And then ultimately there will be a final decision, but that's not the end either, because sometimes you can go to court and argue that all the way through. But generally, once Triple R is done, that generally concludes the proceeding, and then that means that this is the decision of the commission is the way to move forward and gives direction to the company on what they then shall do from that case. So in this case, the commission is considering what is called a certificate of public convenience and necessity. So what this means is the company is asking the commission authorization to do something. Usually it's for new services or infrastructure investments, and especially big dollar infrastructure investments. So generally, if the company wants to spend, $1 million on something, that's not like a blip on the radar, and they kind of just go do it, and none of us really look at it. In this case, we're talking, $150 million in investments, and that used to be a big number with Xcel, but it's not that big a number with them anymore, unfortunately. We usually with Xcel now talk in the billions of dollars of investments, so this is a small dollar amount relative, but this case also has pretty interesting policy implications. And the dollar amount plus the policy implications are why this is getting so much attention, why I'm kind of up here, why you're going to have public comment hearings and that kind of thing, because this case represents kind of a very unique place in kind of policy development for the PUC. So what the ultimate outcome of this will be is the commission will say, all right, you have authorization to do these things. It, with that then, implies that the decision or the authorization that the commission gives to the company is operating under this public interest standard, right? So you're getting permission to do this, and inherent within it is the public interest, and so when you do this, you're operating, under the authorization of the commission and in line with statute and rules and laws of the state. It's going to set the guidelines and conditions for implementation. You can do this many miles of this, or you can invest in these different type of infrastructure things. And then it will also set the terms for future review and prudence determination. So ultimately, all the things that are done in this proceeding will come back to the commission in a rate case or some sort of rate review, and they'll look at it and they'll say, we authorized you to do this, you spent this, and was this, in line with what we said. So CPCN is different than a rate case. It's different than a resource plan. It's really specific about this project and how it fits into kind of the bigger, broader landscape of how the company operates. Yeah.
I think you just touched on it, but is it pretty common for a CPCN to be granted and then the company spends the money and then comes back to recover those costs? Or do they have to propose how they're gonna do the work and recover the costs before they even get the CPCN?
So the question, I'll try to summarize here is it the common practice where the commission authorizes a CPCN, the company then goes and does the work, and then comes back and asks for rate recovery? Or is it more common, can you repeat the second part?
Yeah,
I'm sorry.
to propose how they're gonna recover the costs before doing the work.
So is it,
So
or,
they're asking for refund or for cost recovery after doing the thing, or are you asking
Yeah.
for approval to do the rate recovery at the beginning?
okay, so I think maybe the question is, what is more common when a company asks for recovery? To ask for recovery at the front of the project or to wait to get recovery afterwards? I would say both are common. You have to kind of understand the interests of the parties a little bit to see who would argue one and who would argue the other. The company, when it does a project, wants to get its money for that project as soon as possible, and that's what's called reducing regulatory lag. Parties like ratepayers want to wait till the project is done and gets review for the company to get money, because there's a time value in that that's worth some for customers. But usually you will see the company ask for contemporaneous recovery through like a rider or that kind of thing. It's more common, I think, for the commission to ultimately say, come back and ask for cost recovery in a rate case. But it just depends on the project, it depends on the dollar amounts, it depends on like what the legislature says they can do. Does that help?
Yeah.
Okay. Okay, so maybe let's talk about this project a little bit in particular, and then we can talk about public hearing, and then I'm pretty done. So the Mountain Energy project, I mentioned that this is an important case because of the kind of confluence of the dollar amounts, but more importantly, the policy issues that are related to it. And I'll try to give my perspective on this policy convergence in particular. So the state legislature in the last few years has laid out decarbonization goals for the state broadly. And they've also laid out decarbonization goals for the natural gas sector in particular. And those goals have been implemented or are being implemented through a couple processes. Some are called the Clean Heat Plan. This is where it's their core plan to say we are going to reduce emissions from our natural gas system, and this is the way we're going to do it. And we're going to try to meet the goals that the state has laid out. We've gone through that process. I'll say this is more my commentary, not the commission's. This has been a challenge to meet the goals that the legislature has laid out. Matter of fact, none of the utilities in their plans have been able to come very close to this goal at all. It's very difficult in a context of natural gas system continues to expand, but to reduce emissions, you need to reduce the amount of actual throughput. And this has been a challenge for the utilities to meet that goal. On top of that, a few winters ago, we had what was called Winter Storm Uri, which spiked the cost of natural gas considerably. It went something like from $40 to $140 per unit, and it transferred statewide something like $1 billion of extra costs in natural gas over President's Day weekend. So that was spent just over 4 days. And the legislature heard from lots and lots and lots of customers, like, we are mad about this. And so the legislature implemented another bill called Senate Bill 291, which was a consumer protection bill that said, Commission, you need to do everything you can to put downward pressure on rates and reduce costs from volatile gas systems and whatnot. So we have these kind of two big policy drivers and that are kind of like overarching for policy in the state. And then we have what's actually happening here on the ground, which is in the mountain communities or the communities that are involved in this filing. We're seeing capacity, the company is proposing that there is a capacity constraint on its system to provide natural gas here. And so its plan is based on its analysis to say, these are the things we want to do to address the capacity concerns that we have for the mountain communities. If I can take an aside, what I can talk about, is it worthwhile for me to explain what capacity is, or is that interesting to folks? So a little bit, I'll try to be brief. So the way a gas company designs its system is it says, all right, here's all the pipe that we're going to have in the community. And we're going to look at all the buildings and different users that are attached to that system. And we're going to figure out and size the system based on the natural gas that all those users might use or could possibly use on the coldest day of the year based on the 30-year average. I think it's 30 years. So it says, like, if everybody in this room was attached to the natural gas system, on the coldest day, we all fire on our furnaces and turn on our driveway, ice melts, and then go out back and fire up the natural gas fireplace and then fire on the grill. Like, if we all do that, that's the maximum amount of gas that we need to use. And so we're going to size our system based on that. That's the capacity of the system. Now, what part of this case is going to be is to figure out, is that the right calculation or not? And do the utility need to size the system? And so that is what's going on broadly in this case. The company has proposed that its answer is to spend $155 million to address this capacity calculation. And they're going to do it in a couple ways. They're going to spend about $50 million on what are called non-pipeline alternatives. And this is directed at them through statute. And this is to say, when you are going to propose capacity projects, you also have to look at alternatives that don't involve pipe. And this comes from legislation that kind of imagines a future in which we're not using as much natural gas and that pipes in the ground cost money for a long time, something like 40 to 60 years, and that we're promoting electrification in the state, so we will imagine that lots of people will move off the gas system in the future. And if we continue to invest, a smaller pool of customers, often those that are least likely to leave the system, will be paying for the costs of all of this. And so this is non-pipeline alternatives, is the legislature's direction to say, you look at alternatives before you put pipe in the ground. So they've come up with about $50 million in projects. This is like demand side management and beneficial electrification in particular. Insulation, heat pumps, those kind of things. Then they have also proposed $79 million in compressed natural gas and liquefied natural gas equipment. And so I think somebody mentioned before yesterday or later this week, they drove by the mobile liquefied natural gas system that they have out there that they're using as emergency backup for capacity issues that are existing right now. They're proposing a more permanent liquefied natural gas, compressed natural gas station as the primary mode to address the capacity constraint. And then there's another $30 million in electric system or distribution system upgrades that are tied to the non-pipeline alternative. So when you move customers toward electrification, you need to then upgrade the distribution system to accommodate those capacity constraints. So it's kind of like this back and forth. And so that is the project broadly. As if you've reviewed the case, there's a wide variety of opinions on what is the best approach to addressing this capacity constraint, whether that's like modeling assumptions, whether using the coldest day in the last 30 years is the most appropriate way of determining capacity, whether natural gas and compressed natural gas is the proper approach, how cost recovery will be allocated within this case, to whom it will be allocated. There are lots of different perspectives that are kind of brewing up on the proceeding, but that's the general framework of what the commission will consider. So I'm sure there's questions and stuff on this. So.
Okay, apologies because this is nerdy. So does the CPCN govern the entire proposal?
That's a great question, and I'll start by saying this is all nerdy, so we don't have to worry about the question. So the question was, does the CPCN govern everything that happens within the project? Yes. So the commission will determine like the scope of the project, what the balance of these dollars will be, how the cost recovery will happen, how it will be allocated. The entirety of the project will sit within that CPCN, and that will be the governing decision.
So some of the answer testimony from the intervening parties recommended denying the CPCN, but allowing for the non-pipeline alternatives to move forward and start right away. So if you deny the CPCN, can you also then allow these other elements of the proposal to move forward?
So the example given was in some answer testimony, the party has proposed to deny the CPCN, but to approve the non-pipeline alternatives that were also proposed by the company. I think, my answer would be the commission has broad authority to decide what happens in the proceeding. I think, this is my opinion, not like an absolute legal opinion. I think it's more wording or like kind of, it would be more wording than substance to say, deny the CPCN and then do this, because what would actually happen in that case would be, what the commission would do is they'd say, we're denying all of these things within the CPCN, and the only thing we're approving within the CPCN would be these non-pipeline alternatives. So the commission generally, and this has been affirmed by the Supreme Court here in Colorado lots of times, is the commission gets very broad authority to do what they want. And so they can adopt whole heart, a proposal. They can pick and choose different parties. They can not do what the company says at all and go with, an alternative. And so broadly, they can decide. I think I'd be pretty confident to say, something will come out of this case. What it is, I wouldn't speculate yet. So, I think there's a question over here, and then we'll go over there. Yeah, go ahead.
Okay. You mentioned the clean energy plan that came from the state legislature's decarbonization goals. When was that published, or when was that plan published? Or designed? About?
The Clean Heat Plan for Public Service was filed, I'm going to say early in 24. I can probably afterwards maybe help track down the numbers. It could be 23 as well. These proceedings take a long time, as you all are finding out. And in that case, there was actually a pretty large expenditure for public services, something like $500 million over 3 years, and it included lots of things like beneficial electrification and demand-side management. One of the, is again an aside, one of the interesting things about clean heat or decarbonizing the gas system is there aren't a lot of commercially available tools to do this right now. A lot of it is just use less and move to electricity to reduce emissions. Yes, sir.
So I know the process is somewhat indeterminate in terms of timeline, but about when does CPCN hope to have a conclusion?
Yeah, so the commission has 250 days from when the application was deemed complete to make a decision. And so I think we can look, I'm not going to do the math in my head. I'll get you the final date on that. The question was, when should we look for completion of this proceeding? I mean, I think we're still probably 6 months away or so from seeing, maybe 4 months from seeing kind of conclusion. But the caveat to that is the commission also has the ability to implement, an extenuating circumstances clause where they can kind of drag this out. I wouldn't imagine that would happen here, but it's possible.
I have another question.
Sure, go ahead.
From what I understand, in our county, right here, Summit County, our commissioners, county commissioners, supported 100% clean renewable energy by 2035. But that date conflicts with the CPN or the Mountain Energy Project, I believe. Does it or not?
So the question is that Summit County has established its decarbonization goals. And that may conflict with the Mountain Energy Project, but I honestly, I'm not informed enough to answer that question.
Connie, that's a renewable electricity goal. So,
Yeah.
they're separate because this would be,
So this is gas.
This
and
is
we have-
gas.
Ours is electricity, so this is a gas project.
yes. It's
Oh,
with
wow.
gas and electrification.
Yeah, all right.
One thing I'll say broadly for the commission is the state goals around gas emissions will be, I would imagine will be considered relative to the capacity expansion here. I mean, they will be weighing, or I think the commission understands every time they make a decision about gas system that it has impacts, positive or negatively, on the state decarbonization goals. And so likely that tension will be part of the hearing and the deliberations. And if you look at different parties' positions in the proceeding, you can see that already. Like there are lots of push and pulls in a lot of these cases. Generically, the commission is trying to figure out decarbonization goals and economic development and customer rates and all of these things at the same time.
Thank you.
Go ahead.
general precedent of cost recovery has been to look at the ratepayers across the state, not just the ratepayers within a particular region that's being impacted. And yet there's been answer testimony that indicates, and commissioner comment that indicates that that's perhaps not the way you guys or the PUC are looking at that issue right now. Can you talk a little bit about why the departure from the past precedent?
So the question is about cost recovery approaches broadly and where we are in that conversation. I think this is an important question, and this is one of those like really important policy issues that we don't know about yet. And that's what I think that's one of the reasons this case is so important. So broadly, or like for a long time, cost recovery for anything has generally been, any one thing has been socialized across all customer classes and allocated to different customer classes in different ways. So, a power, to not talk about gas, a power plant gets built. And then that cost gets spread across all the customers based on their usage and based on how they contribute to peaks and the need for that plant to be built. And that's kind of been the very basic kind of way that rate making has been done. So when you pay your gas or electric bill, it's for the broad infrastructure of the system. And that has generally been, that has been the approach. Then we move into this decarbonization framework, and the legislature starts giving guidance to the commission in the way lawmakers do, right? Like broad kind of sweeps and like general statements about what they want done. And there seems to be indications from the legislature that for the commission to consider costs and cost signals and allocation of costs in different ways to try to support decarbonization. And but they're done in a way that the legislature would write a law, and we don't have like a lot of guidance or rules on what actual implementation looks like. And so several parties have weighed in the best they can on saying, this is the way we think that the legislature or the commission or whatever has said approach this issue, and here's how you might implement it. And so this is an important question that the commission will take up. But how it's resolved, we don't know yet, because this is like a first impression around this issue. And I think all parties are anxious to see how this particular issue might come out. But it has implications on both sides. I'll say from like the ratepayer standpoint. Like generally when you socialize things, it cuts costs for the individual, right? Because it's spread across, 1.5 million customers. And so you pay less. And then vice versa, like if you allocate specifically, then certain customers pay more. And so the commission is going to need to figure out how it wants to treat costs like this and send price signals and all of those kind of things. Did I get to the root of what you're trying?
A follow-up question, though, in
Sure.
terms of process.
Sure.
When the PUC, I don't want to make sure.
Sure.
Disclosure purposes. So when the meet with us in our work session, one of the things they said was that it's helpful for the PUC commissioners to have some context about the community that this may impact. And obviously, in an incredibly high cost of living community, that issue is of paramount importance. So in your experience at these hearings, is it appropriate for folks to share some of their experiences with affordability as context for the commissioners more broadly than just talking about that particular issue?
Sure. So the question is it appropriate or is it useful for the public to share the economic impacts of the decisions that the commission might make? So yeah, I would say absolutely 100% yes. I think any perspective is useful. This has been something, in other cases. So recently I've been in Steamboat and Hayden and Craig dealing with, supporting communities relative to plant closures there. And certainly that has economic impacts too. And that has been like a very important part of, public comment there too. So I would say 100% yes. And we'll hit on that a little bit too.
To go back to the original question around geographic cost allocation, it's my understanding there is also an open proceeding on that very issue concurrent with the Mountain Energy Project. Do you have an update or a summary of that proceeding? And it's a very different type of proceeding, so what are potential outcomes from that one that we could expect to see?
Yep. So the question. I don't either. But the question is, there's another proceeding that's going on through direction from the legislature that addresses the issue of cost allocation of the gas system. And is there anything we can learn from that proceeding? So the answer is there's some overlap, but the timing on these two proceedings are not good in that this proceeding will be over before this other miscellaneous proceeding actually even really gets going. I will say the common thread between the two proceedings is the commissioner that's hearing the Mountain Energy Project is also the commissioner that is overseeing the miscellaneous proceeding. And I imagine there will be some tie and direction on how she thinks she might go in the case. Okay, let me hit on a couple more things, and then certainly we can have more conversation. But how to give public comment. There are two opportunities coming up for the public to provide comment. One we've already kind of hit on, which is a week from today in this room, right? This room. Commissioner Gilman will be here to take public comment. In addition, there will be a remote public comment hearing on August 4th, where she will also, be available by Zoom to take public comment. This is the link to register. Basically, you quick little Google form, then the commission will send a Zoom link to anyone that wants to participate, and they'll just take comment kind of in order as they come. You can also submit written comment at any time until the case closes to the commission. This is, and you can also do both. And to kind of lay out, what the public comment hearing will look like is, it is, more of your formal, NEPA kind of related public comment where the commissioner will come, she will be set up, I don't know, behind this table or behind a desk or something. There will be a court reporter here. There will be PUC staff, and she will hear public comment, but will not engage in, a back and forth, will not answer questions, will be really here to listen. And so, this probably for, a lot of like government officials and folks were familiar with this forum. But for the public, this is kind of oftentimes a frustrating exercise in that, like, we're not super well informed and we hear this is important and I have something to say, but I also have a lot of questions. And so this forum doesn't lend well to that kind of exchange. And so the commissioner, because she's in the middle of a hearing and she's gathering evidence and all that, really cannot have a back and forth. And so it will be kind of that forum, right? She will be here to listen. There will be a line or there'll be chairs, and then, people will be invited to come up to the dais and give comment, and that will be kind of, when they're done, that will be kind of the finality of that comment, right? And so I think it's important to kind of lay out that context. Depending on how many people are here, the commissioner, if there's just a few folks, the commissioner will likely take longer comment. We've had comments in Pueblo at one time. We had, something like 300 or 400 people. And so in that case, folks had 2 minutes or 3 minutes to give comment, and they were on like a light. It was like, okay, we're starting your time, and when the light goes on, that's kind of it. And so depending on how, the meeting is structured, that's what it'll look like. And so sometimes it can be really short. So you have the opportunity to give, verbal comment, but there's also an avenue, if you have more to say than what happens in those 2 minutes, to send in written comment. Written comment and public comment are officially not part of the record until they are entered in the record. And our office kind of takes it, as one of our tasks to always make sure by the end of the proceeding that all the public comment has been entered into the record officially. So we'll attach it to, one of our analyst comments, or we'll move it at the end of the proceeding, but we work to make sure that all the comments in the entirety are included in the record as well. So that's the general process. For delivering effective public comment, these are kind of the 7 bullets that I've come up with that seem like this is how we can kind of drive home and keep like comments focused, so that the commissioner sees what the citizen really is trying to say. I'll say, like, I've been to enough where, and given the time constraints, where I've seen it like kind of go, I hate the utility. The utility, is not good. These are all the things, and then the time is up, and nobody kind of really got to like drive home what they're trying to say. So, so my tips for effective public comment is, write down your comments. I do a fair amount of public speaking. When I leave today, inevitably I'll say to myself, dang it, I forgot to say that I always like to say, or whatever. So if you write those things down, generally it keeps you focused on where you want to go. Use natural language. I think in these formal proceedings, folks tend to think like, oh, I'm in front of a commissioner, or I'm in front of a judge, and I have to sound really professional, and I have to like use lawyer language, otherwise they won't believe me when I say it. That is not the case at all. The commissioners want to, they hear from a lot of professionals all the time. They don't want to hear more kind of professional, thought out, strategic speak. They want to hear what you have to say in your own voice, in your own experience. The 5 things I could say that generally drive home are like, tug at, the humanity of the commissioner, is tell them who you are. I've lived in, Summit County for this many years, or, I work here. and you know, I came here 20 years ago from this for this reason. Like, humanize, you know, who you are and why this is important to you. Tell them what your experience with the PUC is. Until last week, I had no idea that there was a thing called the PUC, and I had no idea that it actually makes like meaningful decisions for me. But this matters, and I'm here because you know, I think you can help or whatever. But like, relaying your experience with the PUC matters, because I think it reminds them, like, we do this thing over here, and nobody else in the public really knows what we do. And so the fact that you're here, you know, matters, and it's important. Tell them how this will impact your community, either positive or negatively, right? This is the thing I imagine that will happen if you make this decision. Why does it matter? You know, I think this is for commissioners and that kind of thing. This is maybe more easy to articulate, but you know, for folks that, you know, work in the construction industry, maybe this means jobs. For folks that are, you know, the decarbonization is important to them. This is why this matters. So really relay, you know, why it matters for you and your community. And then I think the most important thing, if you can, is to make a recommendation to the commissioner on what you want, right? Adopt the plan, don't adopt the plan, you know, do this, do that. Because that's like really kind of, I think, how they're gonna how the commissioners organize, like where the public comments come in, right? This is what I want you to do. I think this is the most important part, and it's like a good way to kind of cap comment, because I think, you know, it gives the commissioner something, you know, to really latch onto about each individual perspective. So we have seen kind of when this recommendation is made, the commissioners kind of really latch onto this. I think, you know, in my experience in Craig, in Steamboat, in Pueblo, in Canyon City, you know, when the recommendations have been kind of clearly articulated, I have then heard later in deliberations and that kind of thing. When we were in Pueblo, we heard numerous public commenters recommend this or recommend that. And so I think that's kind of the pipeline for how commissioners can really like use public comment in their decision making. So that is kind of my wrap up. Here is my contact information. I'm certainly available through email or my cell phone if folks have questions, if there are other things that come up, more questions. If this stimulating presentation really like puts a lot more questions in your head, I'm happy to chat with folks on this. Again, I appreciate the invitation. I'm happy to have more conversation or questions if folks have it. There's still a lot of food, so you probably can take some home if you want and feed some other mouths, because I won't. So thank you again for the invitation. I appreciate being able to come up and meet with you all and, you know, have a couple hours of your evening. So thank you again.
Thanks, Jim.
Yep. Mm-hmm.